The high-profile shooting case in Lubbock, Texas. He's off the hook criminally, but now he's on the hook potentially civilly. Stay tuned, we're going to break it down for you. Hey everybody, this is attorney Andy Marcantel and attorney Marc J. We are the partners of the Attorneys for Freedom law firm here today to talk about another crazy shooting video that happened out in Lubbock, Texas, and involves both the criminal analysis and the civil analysis. How you doing today, Marc?
Great, man. You know, this is probably my favorite thing to do. I love looking at these videos and trying to pull them apart. We're speculating about things here, but this is what we do, is pull apart the evidence and try to teach and try to learn and try to have a discussion that people can take something away from.
Yeah, I like when we get to put on both of our hats, right? Both the criminal side and the civil side, because we tell people all the time, when you draw your firearm, keep in mind that even if justified, you're probably in for years of aggravation. And when you're ultimately acquitted, or in this case, if a grand jury returns no true bill and doesn't ultimately indict you, you're not out of the woods yet necessarily, right? You could be in for more. So why don't we start by looking at the video?
Yeah, let's do that.
All right.
Get off of my property.
So he told him to get off the property very clearly there.
Well, so this guy's substantially bigger than Mr. Caruth, I think is how we say it. He's clearly agitated as well.
Confronting a third party right now, very aggressively.
Yeah.
Closing in. Getting closer. She's backing up.
If you want to see him, you see him up until 3:15. You keep trying to keep my son.
We could accurately describe his posture as very aggressive right now.
Yeah, typical domestic violence dispute right here. Okay, here we come with the firearm.
Do it right now.
Leave right now.
I'll take it from you.
Call the police. Call the police. Call 911. Call 911. Call 911. Call 911. Call 911. Call 911.
All right, so looks like he comes out with the firearm, once again tells him to get off the property. He yells, "You better use it," and I believe threatens to take the gun away from him.
This is Mr. Reed.
Mr. Reed,
yeah, the
right.
guy who ultimately, he's deceased here. Also, he's right in his face. He's got the chest puffed out. He's clearly threatening physical force, and he's big enough that I think the threat could be perceived as a potential serious physical injury. So I think you got a lot here that justifies the use of deadly physical force, at least at that moment.
Sure. So Kyle Caruth is the defendant in the case. He fires a warning shot. This is a really, really important part of our analysis, as we'll talk about. And then after firing the warning shot, he continues to get up in his face, yell at him, and actually attempts to grab the gun. I think grabs the barrel of the gun and kind of shoves him back. Mr. Caruth turns around and points the firearm. Now, at this point in the video, Mr. Reed is off camera, and this is also really important for our analysis, as we'll talk about, but then pulls the trigger twice, drops him, and as you can see, he is laying face down there with his back facing up, which I think can give rise to some speculation. So, Marc, what are your thoughts of this?
A lot to unpack here.
Yeah.
What we're calling the warning shot is Mr. Caruth, looks like he fires one into the ground. And then you hear the discharge of the weapon maybe a second or so after you see it. So I think that is important, right? Because what we like to see as defense lawyers is an escalation of force. If you can. I mean, sometimes you don't have this opportunity, but if you can, right? He comes out, first he's calm, he tells him to get off the property. He's not pointing the gun. He doesn't come out pointing the gun at this guy, and I think that's an important fact too, right? He comes out, he's clearly in a defensive posture. He tells the guy to leave. This other fellow gets right up in his face, chest puffed out. He looks like he's the aggressor. He is the aggressor. You know, at that point, you could even make an argument, in my opinion, that if Mr. Caruth shoots him right then and there, you got a justified shooting. I think that there's a very good argument there. But then this other fellow, Mr. Reed, continues on, you better use it. There's a lot you can read into that type of a statement, right? You better use it. In other words, I'm going to do something really serious to you. You better use this. It's a pretty imminent threat. So I think that probably played a big factor in the grand jury's deliberations. And then I think maybe the most important fact in the whole thing, this "I'll take it from you and F you up" is what I heard in that video. That's a very powerful fact right there. And I'm sure that the grand jury, if I'm on the grand jury, that's going to be a very overwhelming, powerful fact for me right there. I think all that's really critical.
Yeah, so, and you talk about the warning shot that then follows after those verbal threats, and just to kind of make it really clear what you mean by an escalation of force, because technically walking out with the barrel pointed right at his face is an escalation of force.
Yeah.
What we're looking for is a gradual escalation of force.
That's a good point.
So that people are clear out there. In other words, we want to see that the defendant has done everything that they possibly can to not have to pull the trigger of that firearm.
Yeah, I want to make the case that my client, right, the person who generally is charged with the crime, used the least amount of force that was necessary to repel that imminent threat. And so here, and we hold police officers to the same standard, right? They got all kinds of tools at their disposal, and they're supposed to escalate force as needed as well, too. And so I like that Mr. Carruth, he doesn't come out with the firearm pointed. He's not making threats. I think the shot into the ground is really good. He's in close quarters at that point, so you really can't blame him if he actually shoots this guy at that point. The only part that gives me any hesitation in this video is after Mr. Reed tries to grab the gun and Mr. Carruth is holding on, he kind of swings around and he's still got the gun in his hand, and then he aims it at him. We can't see exactly where Mr. Reed is at that point.
That's critical.
Now, I think we can assume he's right around where he is there, right? But there's some space between the guys at that point. And we don't have any reason to think that Mr. Reed is armed or has a knife or anything like that. I mean, if he does, if he's got a gun, if he's got a knife, then it's an easy one, right? But now you got an unarmed guy, and you got a gun in his face, and there's some distance between the two of you. So if I'm a prosecutor and I'm thinking about bringing charges here, that's the part that I'm going to make a big issue. Like, what is the imminent threat at that point? Now, admittedly, Mr. Reed, has done all these things, and he could close. He's a pretty big guy. But could you have just said, look, man, I'm going to blow you away. Put your arms up, step back, get the hell off my property. Like, could he have done something along those lines? Or he could have stepped back with the firearm pointed at this guy and created some more distance. But we're in Texas here. And you can't ignore this part of the analysis, right?
That's right. Texas law treats homeowners with trespassers on their property very, very leniently. There's lots of protection there. Arguably, that's the way it should be in all states, but definitely in Texas. Because he was clearly a trespasser, there were certain rights that were gained immediately by the defendant in this case, and the grand jury was no doubt informed of all of those things. But I wanted to kind of flesh out a point that you just made, Mark, which is that based on this video, we have no reason to believe that the guy is armed. And I agree with that. I don't see him going for his pocket or anything like that. But also relevant in this analysis is things that the video doesn't show, things that are in the mind of the defendant. Because remember, what we're trying to show here is reasonableness and whether or not somebody is criminally liable for the death of another human being depends upon what's going on in between their ears, right? So, for example, if Mr. Carruth had any sort of prior knowledge of Mr. Reed carrying weapons, being violent, maybe he knows that he's been violent in the past to his ex-wife, now Mr. Carruth's current girlfriend, I believe. That's really relevant to the analysis,
right? It's a great point. Prior knowledge of violence or prior conduct, those kinds of things, definitely relevant. And we don't know what's transpired here in the past, what Mr. Carruth has got in his head. But, it's got to also be objectively reasonable, considering all those facts. And I like that the prosecutor in this case, instead of just filing a complaint, and we're going to charge this guy, did what I think is appropriate in a case that's kind of a close call, right, where there could be reasonable minds could disagree here, presented to the grand jury, right? This is the best function of the grand jury. Let the people in the community take a look at the case, and then they get to decide whether or not there's probable cause here to charge this case. And in this case, from what I understand, the grand jury took 3 days, called witnesses, looked at every scrap of evidence, really thought about it carefully, and then decided not to indict.
Yeah, we should talk about the grand jury process because a lot of people don't know about the grand jury process. And so, in a nutshell, the prosecutor typically has a couple of choices in the beginning. When something like this happens and is brought to the attention of the county attorney's office, they have a couple of options, one of which is, as you just said, to simply file a complaint and let a judge perhaps figure out whether or not there's probable cause to proceed later on down the road in something typically called a preliminary hearing. This is where a judge kind of weighs what evidence is out there and determines as a preliminary matter whether there is at least enough probable cause to proceed with the charge. It's obviously that's not a question of guilt or innocence.
Right.
That's a much, much lower standard than the proof beyond a reasonable doubt required for a conviction. But the other option that a prosecutor has is to let the people of the community decide, and that's what a grand jury hearing is. So these are typically secret proceedings. These are typically a gathering of people from the community, just like you would with a jury at a trial, and they're impaneled and sworn in, and their duty is to listen to what the law is, look at what the evidence is, maybe call witnesses if it's a particularly in-depth analysis or a case of public interest like this case has become, and make a decision whether, without reaching the question of guilt or innocence, obviously, because that's not the role of a grand jury. They're the gatekeepers. Their determination is there at least enough probable cause to proceed with the charges? That's what happened here, and the grand jury in Lubbock said, no, there's not.
Yeah, and we defense lawyers have a saying about grand juries, which is generally that a grand jury could indict a ham sandwich for first-degree murder.
Right.
The reason we say that is because, we've seen so many grand jury proceedings, but there are things about the grand jury that we don't love, right? Like, for example, it's a secret proceeding, and so the defendant doesn't get to go, doesn't get knowledge of the grand jury, doesn't get to present anything. There's no defense lawyer there. There's no judge there. The only people in the room generally are the members of the grand jury, the prosecutor, the police officer, who can bring in hearsay, right? They can say, well, I spoke to another officer or another witness.
And just to say a word about the level of secrecy of this hearing, in many jurisdictions, it's even a crime for the prosecutor to inform anybody when the grand jury hearing is going to be.
Right. So you don't get notice of this. Now, different states have different rules. Sometimes you can write a letter to the prosecutor. If you know in advance, hey, this thing might be going to the grand jury. Here is some clearly exculpatory evidence that tends to show that my client really didn't commit this crime. Make sure you present that to the grand jury. And then if they don't, then you can generally complain in a motion to remand, send it back to the grand jury so they can do it again.
Yeah, let's take a moment on that point. That's a really cool point that some jurisdictions have in their rules, which is that if we put the state on notice saying, hey, I want this presented to the grand jury because it's, as you said, clearly exculpatory. That's just fancy lawyer talk for saying it's going to make them less likely to indict my client if they're informed of it. So, for example, in this case, we might demand in that letter to inform the grand jury of the trespasser statute in Texas and the self-defense statutes in Texas and the defense of a third party statutes in Texas.
And as you mentioned earlier, prior knowledge.
Any prior knowledge or information that Mr. Carruth had about Mr. Reed's tendency towards violence and history and everything. We want that presented to the grand jury when you guys go is something that we would have asked for in this case.
And as a footnote, this is why it's good to get a lawyer right at the beginning, even before there are charges, because we had not too long ago, I think it was a second-degree murder or manslaughter, that we brought some exculpatory evidence. We won that. We got it remanded back to the grand jury, and with the new evidence, they failed to indict.
That's right.
So we saved someone having to defend against, I think it was a manslaughter. Yeah, it was a manslaughter case.
We also recently had one with an aggravated assault. After we presented the evidence to the prosecutor actually did present it to the grand jury, to their credit, and the grand jury, to their credit, said, oh, no, now that we have that information, we're not indicting anymore.
So why do we defense lawyers not like these things? Well, years ago when I first started practicing, they used to put the timestamps on these grand jury transcripts. Because remember, I said the court reporter is there. This may vary by state as well. Like in the federal court, it's very difficult to get the grand jury transcript. But in the state court, you can get this. And they used to put the timestamp on there, and it would read something like this. Testimony ends at 2:05 p.m., The room is cleared. The grand jury deliberates. The grand jury comes back at 2:07 p.m., so you get 2 minutes of... These are the types of things I used to argue. Hey, judge, this wasn't a fair hearing. They only deliberated for 2 minutes. How could they possibly have, gone through all the evidence and this and that? So oftentimes they don't include that stuff now, so we don't really know how long they deliberated. But in any event, the grand jury did, I think, the right thing in this case, right? They looked at it. And
of course, they deliberated for longer than 2 minutes. It sounds like they actually discharged their duty, right?
Yeah, 3 days, and then they come back and they say, nope, not enough here. Not enough for a criminal charge.
Liability.
Not enough for a criminal charge. Now, another problem with the system that's probably worth noting is there's usually nothing that stops the prosecutor from representing it to a different grand jury or then filing a complaint and trying to go the preliminary hearing route over and over and over again. I think that's an improper use of the prosecutorial function. I don't think they should do that. If the grand jury says no, that should be the end of the criminal inquiry.
Yeah, and there's even certain ethics rules that might be implicated here if a prosecutor fails to get an indictment and then just decides to file a complaint anyway, which completely defeats the purpose of bringing it to the grand jury in the first place. There might be an argument of prosecutorial misconduct or a misuse. In other words, there might be ethics rules, not legal rules, but ethics rules which might get involved there.
I think it's important to mention also that if the grand jury had come back and said, okay, we're going to indict this guy, I think most of the programs, certainly the attorneys on retainer program, we definitely, if this guy had been a member, would be representing him. Most, I think, of these programs would say, all right, this guy's got an arguable case for self-defense. So even the insurance-based companies that say we exclude criminal acts would probably conclude, and I could be wrong here, but would probably conclude, this thing here is an act of self-defense. It's not a criminal act. He's presumed innocent, and therefore we will pay some money. Now, of course, as we know, this guy had taken a deal, and of course, this would be probably manslaughter case or something along those lines, and this guy's looking at a lot of time, right? So you got to think how you chart this out if this guy does get charged. He's looking at a manslaughter. He's looking at a lot of time in prison. Prosecutor comes up and says, hey, here's an involuntary manslaughter, a negligent homicide, some lower level. You get probation, you move on. It would be very hard, I think, for Mr. Carruth, or most people, to roll the dice in a close call. So he maybe takes some kind of a deal to stay out of prison, and boom, you just lost, at least for some of these insurance-based coverages, and some of them have come out and flat out said, if you take a plea or you're found guilty, all coverage ends.
Right.
So then where does that put you now? Not just for the sentencing coming up, right? You may have to earn probation from that judge, the sentencing judge, but now the civil suit follows. Well, if you've lost all coverage, you might have had a great civil plan that said, hey, we'll defend you, we'll pay the judgment if you lose. But if you took a deal, you just lost everything.
But before we even get to the civil, before we even leave the criminal realm, who's going to handle your sentencing, but who's going to handle your appeal, right? So
That's right.
All of these companies that proudly tout that they cover appeals, you and I have been asking for a long time when we see it, it's like, how do they get to an appeal? Because in order to get to an appeal, there needs to be a criminal conviction.
The other thing that I think some of these other companies might look at is say, well, okay, it looks like a valid act of self-defense, and we're okay over the exclusion for criminal acts, at least unless and until someone pleads or is found guilty. But this thing's an act of domestic violence. He's defending a third party. It's clearly a domestic violence dispute. This, I think, is an ex-spouse situation. And many of these companies, not all of them, but many of these companies say, we just flat exclude domestic violence matters.
Yeah, to be fair, it depends on how the jurisdiction defines a domestic violence incident. Some jurisdictions simply define it of what's the relationship of the defendant to the victim.
Right.
So in this case, it's his current partner's ex. So he doesn't have any sort of a familial relationship with the victim. Mr. Carruth doesn't have any familial relationship with the victim. But for another jurisdiction that might just say any act or any crime arising out of a domestic dispute, this very much seems to qualify.
Yeah, so that's the other thing, with these insurance-based companies. Not only do you have to run the gauntlet of the criminal acts exclusion, but then there's all these other things, right? We usually tick them off very quickly and say, well, illegal weapon, sensitive places, alcohol or drugs, and we go past domestic violence. And sometimes we pause and say, look, this stuff comes up a lot in domestic violence. People get heated. This one here is a great example of how these type of situations can arise out of domestic violence. If you got that exclusion, you got one of these other policies, you have this type of an exclusion, this could be a real big deal breaker for you when you really need an attorney to represent you and you think you got it and you may not. As a result.
So no criminal liability, says the grand jury. Good, kudos for them.
Yep.
I tend to agree with them. I also agree with that nuance that you throw on there that we can't see the victim for a second before the trigger is pulled for the 2 shots that ultimately kill him. And his posture during that important second or two where he's off camera is extremely important. But presumably the witness statements were available to the grand jury. They heard a lot more than we saw in this video. So now let's talk about the civil liability.
But before you go there, I just want to highlight one more point. This thing happens in New York. This guy's definitely going to be charged.
Yeah,
right?
okay, excellent.
This thing happens in California. This guy's going to be charged.
Remember that the grand jury that's assembled is a jury of your peers from that jurisdiction, right?
That's right.
So it's
you got people from Lubbock, Texas here on the grand jury. If you got people from San Francisco or New York City on your grand jury, don't look at this video and say, okay, I'm good. I understand what I can do now, because maybe not so clear. There's a lot of gray area in what's reasonable, and people disagree on the word reasonable, right? Widely disagree on what's reasonable. So I would look at this video and counsel people to be cautious and say, in my mind, this is kind of a close call, because at that moment that Mr. Carruth has got the gun trained on Mr. Reed, and there's, 5 feet, 10 feet between the two.
Impossible to say, really, from the video
Impossible
alone,
to say, but it seems like Reed is not armed. And assuming we don't have prior knowledge, as you point out, that's a very big point, you might say, what's imminent at this moment? What are all the did you have what if you're in a duty to retreat state, right? Now, of course, you're at home, so even in those states, the Castle Doctrine protects you here. But, there are many different nuances to look at here. And a prosecutor might say, could he have just said, hey, man, get off my property now that I'm pointing this at you? Could he have backed up himself? Could he have, there's other options.
My first thought when you mentioned a different jurisdiction was perhaps in a different jurisdiction, a more left-leaning, less gun-friendly jurisdiction, the prosecutor wouldn't screw around with the grand jury and simply file the complaint.
That's right, too.
And let the judge, who the prosecutor probably knows also doesn't like guns very much, to make the probable cause determination.
Yep. So this could have gone a completely different direction. But fortunately for Mr. Carruth, it happened in Lubbock, Texas. So you got the right members of the grand jury. By the way, different group of grand jurors here, even in Lubbock, Texas, could have concluded differently here. So we really don't know. But that's the way this one, so we can kind of close the chapter on the possibility of criminal charge and open the chapter on the civil liability.
Let's open that chapter right now, because it's an interesting analysis, but let's get to the timeline leading up to where we are right now. So this incident happens in November 2021. The civil suit, which is a wrongful death civil suit, we'll talk about that in a second, that's filed by 2 members of Mr. Reed's family.
2 different lawsuits,
yes,
I think.
His mother and his now widow both file a wrongful death, and that happens in December of 2021. The grand jury returns no indictment in March of 2022, and then about a year later, in March of 2023, the judge moves to consolidate the 2 wrongful death lawsuits. So I guess we can start by talking about the difference between criminal and civil. What is a wrongful death?
Yeah, because people might be thinking, wait a second, this guy didn't commit a crime. It was self-defense. Why is he now being sued for wrongful death?
Yeah.
And
a lot of it has to do with the different burdens of proof that are required between a criminal case and a civil case. So everybody's familiar with that term, beyond a reasonable doubt. And the idea is it's supposed to be a really high burden of proof that we hold our government to before it can convict somebody of a crime and put you in a cage. Okay, that's fine. But we don't have that standard in the civil realm. In other words, when a private party is suing another private party for damages, like in a wrongful death lawsuit, where the purpose of it is to collect money to compensate me for the wrongful death that you caused of my loved one or relative, we have a much lower burden of proof called a preponderance of the evidence standard. How would you describe a preponderance of the evidence standard, Mark?
well, the way it's often described in law school is 50% plus a feather, right? So just a tad more than 50%. Who do you believe more? So it's certainly possible that somebody could look at this. In fact, an educated mind could look at this case and conclude, I can't say beyond a reasonable doubt that a crime was committed here. But I can say by a preponderance of the evidence that Mr. Carruth was not justified here, that he acted inappropriately, and therefore find civil liability. Now, I'm going to reveal my age here by talking about the O.J. case, because that was a pretty high-profile case, and people remember O.J. Simpson, the famous football player for, I think, the Buffalo Bills. He was on trial for murder, and he was acquitted. He was found not guilty. Then he was sued in a wrongful death case by the victim's family, and he was found liable, found responsible for that wrongful death, and had to pay damages and things of that matter. And so this caused a lot of people to scratch their head. Wait, wasn't he acquitted in the criminal case? He was. But because of the fact that we have different standards of proof, there's nothing inconsistent about saying not guilty of the criminal matter and liable or responsible on the civil side.
Yeah, let's talk about what happened in March of 2023, too, when the judge decided to consolidate these things and reasons why the parties might be seeking consolidation, right? Because probably if we were defending him, we might oppose a consolidation. And the idea here is that if you consolidate them, in other words, put them into the same trial, into the same case, that jury's now going to be seeing two crying relatives, two crying people lamenting about how their life is now ruined because the deceased is no longer in their lives. And typically, if we can cut those up, we might prefer to do those as two different trials for that reason in defending somebody.
And that could be other strategy reasons, right? Let's see how the first one goes. Maybe we can settle the second one, that kind of thing. But in this case, that they were consolidated, put together, and I think that is still pending. That could go on for years.
Yeah, it's tentatively set for April 2024, but as we know from doing civil cases, they move much slower. Much slower than criminal, which is kind of quick, and there's certain time periods and times that the government has to respect in terms of your speedy trial rights. Not so much in civil. They can drag on for years and years.
Yeah, and I think it just as a footnote, even if there were criminal charges brought here, the civil suits could still be brought. Often what happens is on the criminal side, we say, look, this guy's got a right, Fifth Amendment right to remain silent. On the civil side, they say, look, we're going to compel him to enter into a deposition. He's going to take the fifth and say, I got nothing to say at the deposition in the civil case. So oftentimes what happens on the civil side is there's a motion to stay. And so the civil case is put on hold until the criminal case is resolved, including any appeals, because in order to have a Fifth Amendment right to remain silent, you got to be in jeopardy. And they may even make that here, right? Because I probably would if I was involved in the civil case and say, well, just because the grand jury declined to find charge doesn't mean they couldn't represent it if they wanted to until the statute runs out. And so I'm going to take the fifth because it's still possible I could be charged. And I don't know how that's going to play out on the civil side, but if you want to cause some aggravation on the civil side, that's the kind of thing that you might do, is have him assert his Fifth Amendment right to remain silent.
Yeah, so wrongful death lawsuits, states are different. States have different civil codes. Really, the self-defense analysis that we just gave in a criminal context is probably going to come right up again.
Yep.
And whereas the idea is that in the criminal, it's like we have to be absolutely convinced beyond a reasonable doubt that a crime happened here. Something like the point that you mentioned about those few seconds where we don't see the position and the posture and everything like that of the deceased in the video are going to be even more important in this analysis because, well, now we can start to speculate a little bit, because since it's only 50% plus a feather, if there's, for example, witness testimony from the wife who I believe was there on the scene, the one who was maybe filming or yelling, she might testify to the civil court, he was standing there, he wasn't advancing in any way, shape, or form, he was posing no threat, it looked like he was completely done once the gun was pointed at him, and all of a sudden that part of the analysis and the reasonableness becomes even more important.
Yeah, I think it's also important to pull back the curtain a little bit and talk about civilly how we bring these cases. Because people come into our law firm all the time and say, hey, I want to sue for this reason or that reason. And at our firm, we turn down a lot of these types of cases. And the reason we do is because the first question is always, do we have a source of money? right? And so imagine for a moment Mr. Caruth has nothing. Say he's not a rich man. He doesn't have deep pockets, as we say. He's got no insurance, isn't going to cover it because it's an intentional act. So his homeowner's insurance isn't going to cover it. So a typical plaintiff's lawyer is going to look at this case and say, even if we think that Mr. Caruth acted improperly and there's a valid wrongful death case here, we're not going to bring it because there's no money to recover.
Doesn't make financial sense.
That's right. Great to get a piece of paper that says you got a judgment against Caruth for $10 million, and Caruth says, I got nothing. I'm going to file bankruptcy or something like that. There's no money to go after. Now, the lawyer has invested countless hours and money, right, to pay for depositions and transcripts and experts and everything else. And so 9 out of 10 times, the plaintiff's lawyer is going to turn down a case like this. Why didn't they hear? Well, because if you read carefully on the story, Caruth is a land developer. And so maybe he's got deep pockets.
And the lawsuit is not only against him, but against his businesses as well.
That's a good point. So what happened here is the plaintiff's lawyers have said, you know what, there's some source of money here, so we're interested in bringing this case. But if you change the facts and there's no source of money here, even if it's a slam dunk against Caruth on a wrongful death case, it's very unlikely a plaintiff's lawyer is going to bring. How might you change that analysis? You know, I think this is an important point for people to understand. Some of our competitors in the marketplace, people who compete, other companies that compete with attorneys on retainer, because they're insurance companies, they'll say, hey, we'll actually pay that judgment if you get a judgment against you. Now, this is a valid criticism of attorneys on retainer. We don't do that. We're not an insurance company. We'll defend you in the civil case, but if there's a judgment against you, we don't pay that judgment. We're not an insurance company.
That's right.
So that's a valid critique on the attorneys on retainer program. But observe, if we were a plaintiff's counsel, and we were looking at this case, and there was a company out there that says, we'll pay the judgment, well, now you got a source of funds to go after. This is actually operates as an enticement to the plaintiff's lawyer.
Incentivizes them to sue you and keep you in court for potentially years.
Yes, it sure does. It sure does. So in a weird way, the attorneys on retainer program, they say, imagine Caruth doesn't have deep pockets, but has attorneys on retainer. If he gets sued, we're going to defend him. But the first phone call to the plaintiff's counsel is going to be, hey, look, we're going to defend this guy, and if you want to go to trial, we'll defend it. But I just want to let you know, if you get a judgment, we're not paying the judgment. He has no insurance. He has no deep pockets. You're going to get nothing. The guy's going to file bankruptcy, and you're out. And that's going to discourage most, if not all, plaintiff's lawyers right there.
Yeah, there is a perverse
Yes, it
incentive,
is.
maybe an accidental incentive caused by these insurance companies offering to pay out judgments to plaintiffs' lawyers.
And they all have limits. And so even if they're going to pay the judgment, what if the jury comes back, say you got $1 million liability from one of these insurance-based, and you get a $2 million judgment against you? Okay, well, they're going to pay the $1 million, assuming they deliver, and I have every reason to think that the insurance-based companies, I'm assuming they will deliver on what it is they promise. They pay the $1 million and say, have a nice day. And now you got a $1 million judgment against you.
Yeah, and of course, how much their policy and how much they're willing to cover for you is all going to be discoverable. It's all going to be available to the opposite side. So if the opposite side decides they want to hurt you, they want to go after your money specifically, they may choose to request an amount or sue you for an amount that exceeds whatever you're covered by your policy.
Yeah, it's just an interesting point. That's why I say sort of pulling back the curtain, right? How do plaintiffs' lawyers look at this case? We look at liability, money, and damages, right? You got to have all three of those. And if you got no source of money, that by itself, we call that judgment proof.
That's right.
Yeah, that's a term we use. It's sort of an informal term. We say the tortfeasor, the person who committed the tort, which in this case is Mr. Caruth, if the lawsuit is successful, he might be judgment proof because he's got nothing to go after. But in this case, unfortunately, or maybe fortunately for Mr. Caruth, it seems he's got deep pockets, so he bought himself a lawsuit here.
Yeah, so, and just one more point that I wanted to flesh out just a little bit that you mentioned was this discussion of bankruptcy. And this is something that I explain to not only my criminal defense clients that I have, but also when we do victims advocacy cases, the difference between a civil judgment, which is completely disclaimable by bankruptcy. In other words, if you get $1 million judgment against you and it turns out your judgment of proof, file for bankruptcy. Most jurisdictions, that judgment is gone. It is never going to collect. Whereas with criminal restitution, okay, this is a damage caused by a crime and is recognized in a criminal judgment. So in other words, if you are convicted and you cause damage, your crime caused damage to somebody, then they can put a restitution request as part of either a plea deal or in a different hearing after you're convicted. Most jurisdictions do not disclaim those via bankruptcy. So as I explain to clients all the time, the best way to get your money back is through a criminal restitution order wherever possible, because it will follow the person around for the rest of their life. Even if they don't have money now, if they get money in the future, it'll garnish their wages and things like that.
Yeah, and just one little fun thing to tinker around with. Imagine Mr. Reed survives here. And he actually gets charged because the grand jury decides, we're not charging Carruth, he acted in self-defense. But on the other hand, Reed, he's pumping his chest out, he's making throws.
Assaulting.
He gets charged with a crime. Well, if Mr. Carruth had been a member of the Attorneys on Retainer program, and to my knowledge, this is unlike anything else any of the competition to Attorneys on Retainer is offering, we would represent Mr. Carruth as a victim in the criminal case to do exactly what you are talking about, right? So it's first of all say, hey, this guy should be charged. Imagine he's not charged yet, right? We call the prosecutor, say, hey, we're asserting our rights as a victim. Many states have victims' rights acts. Here in Arizona, it's part of the Constitution. You have constitutional rights as a victim, where we go in and we say, look, we're exercising those victims' rights. We would like this guy charged. If he does get charged, we can haggle about what the charge should be. If he does get charged and take a plea, we can haggle about the plea. We can show up in court and complain about the plea. If he is going to sentencing, say he takes a deal or he's convicted at trial, we can show up at sentencing and be heard with the judge. We can have things to say about restitution. I have one right now in this office where we represent the victim and we're haggling about restitution. I'm trying to do exactly what you just explained, get more money on the defendant who's now convicted in their restitution as part of, say, their probation or something like that. So my client, who's the victim in the case, can get more money. So this is another aspect I think people forget about sometimes, because imagine if you are in a valid self-defense incident. Okay, so you're not going to be charged. We still got things we can do for you as a law firm because we represent victims all the time. And it's a part of the Attorneys on Retainer program that I think gets overlooked sometimes. But we like doing...
Yeah, I'm not aware of any of these other programs that offer victims advocacy. And as I always explain to people, we have lots of victims advocacy cases.
We do.
Because, we're criminal defense attorneys, but we also do every aspect of the criminal justice system. And as I explain to my clients who are victims in crimes all the time, you want a seasoned criminal defense attorney as your victim's advocate.
That's right.
Because we know exactly what the weaknesses and strengths are of the prosecution's case against the person who wronged you.
Right.
We know exactly what type of evidence they need. We know exactly how juries are going to treat these types of crimes, and we can help the prosecutor to build their case against them because from defending hundreds and hundreds of them, we know where their weaknesses and strengths lie.
In fact, last thing I'll say on this point is the case I was just speaking of was actually declined by the prosecutor. They said, no, we're not going to charge this guy with a crime.
Which happens all the time.
It happens, yep. And I got involved and had a discussion with the prosecutor and threatened to talk to the supervisor and this, that, and the next thing. And lo and behold, they changed their mind and decided, you know what, I think we will charge this guy. And then he took a deal, and that's what we're arguing for restitution on. So it is an important service. It's an important function to represent victims in the criminal justice system. And it's something we offer proudly as part of the Attorneys on Retainer program. I love doing it. It's fun to show up in court and kind of take the victim's position for a change.
Yeah. I feel like I have to take a shower sometimes when I get done at the prosecutor's table, but I'm proud to do it for the client.
Yeah, so I don't always sit there. But I feel dirty sitting here. But no disrespect to some of our
We work with some great
friends.
prosecutor brothers and sisters as well. There's good and bad in every single aspect of not only the justice system, but of life in general, and broad-brushing people,
No question.
Yeah, but people who are pursuing justice are the people we like working with, and the people who are opposed to it are the people people we love to oppose. So proud of our program. If you guys have any other questions about this video, you think we didn't address the point that you were interested in hearing, make sure to like and subscribe. Leave us a comment down below. We will answer all civil comments, and we'd love to hear what you think maybe we got wrong or what we got right, what you guys would like us to talk about in the future. We love hearing from you guys. Any last thoughts today, Mark?
This was a fun one. I love doing this stuff. If people have videos they want us to kind of critique and analyze, send them over, and we're happy to take a look at them. And if there are issues there that we think can educate and get people thinking in the right direction, we're all over it.
And we'll follow this case. It's set for trial right now in 2024. As we mentioned, that's subject to change, and frankly probably will change just with how the civil courts work. Also, this case could settle at any moment.
Right.
There could be a settlement, and it could never get to trial. But we'll follow it carefully, and we'll be sure to update everybody. Until then, this has been Attorney Andy Marcantel and Attorney Marc J. Victor. Peace.